What amounts to discrimination in employment? Discrimination occurs where an employee is treated adversely solely based on their race, color, sex, language, disability, religion, political or other opinion, nationality, ethnic or social origin, or such other criteria despite their qualifications. Laws exist in many jurisdictions to protect individuals from discrimination in an employment relationship. Employers and employees should be aware of these protections and take steps to prevent discrimination or properly address it when it occurs. In the context of employment, discrimination can occur during recruitment, in the course of employment, and even after termination of employment. We will consider some examples of how discrimination manifests itself at each of these stages. 1. During recruitment. Discrimination at this stage may take many forms as already described above, although in some instances it may not be readily identifiable. For instance, where an employer asks female candidates during interviews questions about their plans for starting a family and uses the answers received as the basis of making a hiring decisions, then gender discrimination can be cited. It is also noteworthy that discrimination does not arise where the particular conduct of an employer arose from the need to take affirmative action. For instance, where an employer prefers to recruit an employee from a marginalized community, if the preference is made with the aim of creating equality. This is taken to constitute a measure in the form of a positive bias that seeks to create equality and is not discriminatory. 2. In the course of employment. During employment, an employer is by law prohibited from discriminating against an employee on grounds of race, color, sex, language, religion, political or other opinion, nationality, ethnic or social origin, disability, pregnancy, mental status, and HIV status. A commonly cited form of discrimination in the course of employment relates to disparity in the pay given to employees for performing the same job. Ideally, an employer is required to pay his employees equal remuneration for work of equal value, and contravening this provision may give rise to discrimination. However, disparity in pay may not always be on account of unlawful considerations. This is because the terms of an employment contract, just like any other contract, is also determined by negotiation between the parties. 3. After termination of employment. A commonly cited form of discrimination after termination of employment is providing negative references for former employees who raised a grievance against the employer during their employment. The foregoing is just a brief overview of matters from which discrimination may arise. It is important to note that in determining whether conduct is discriminatory, courts consider each case independently, meaning that conduct that may constitute discrimination in one case may not necessarily constitute discrimination in another.